Are you looking to grow revenues, increase profitability, or obtain financing? If so, you came to the right place.
Running a business is all about leadership. How do you become a better leader? Learn from the successful entrepreneurs and business owners how to lead your organization more effectively. That's why we created Leadership Live at 8:05, Talking Small Business, to help you succeed with your host, Andrew Frazier, Business Growth Pro and CFO and founder of the Small Business Pro University. Every Tuesday evening at 8 p.m. Eastern, we're joined by experienced entrepreneurs and business owners who share their secrets to success via Livestream. Also, every Friday morning, we release a new podcast episode. Either way, you will learn about developing your business leadership skills from our roster of highly performing guest experts. Leadership Live is one of the many valuable resources provided through the Small Business Pro University, empowering business owners to learn, profit, and grow. Find out more at sbprou.com.
Good evening, everyone, and welcome to Leadership Live at 8:05, Talking Small Business. I'm your host, Andrew Frazier, and excited to be hanging out with you once again. Always look forward to having some great guests on, and definitely this week, I'm excited about having Randy McMillan. We're going to talk about really how to protect your intellectual property, as a business, you know, how you do things. Every business has intellectual property. Some things need to be protected in different ways than others, and some things may not need to be protected. So we're going to have a good conversation around that because, it's important to understand how it works, and better to be safe and prepare than to be sorry. So let's get started. So I'm here with Randy McMillan. I've known him for a long time, actually. I've been working on getting him on the show for a long time, so I was finally able to snag him. But we go all the way back to when I had hair, and actually even long hair. He was actually my brother's roommate at Cornell University. So definitely, he's developed into a tremendous attorney in the intellectual property space. So let's welcome Randy McMillan. Hey, Randy, how you doing tonight?
Hey, Andrew, I'm good. How are you?
I'm excellent. Thanks for joining me this evening. I know you had to catch 2 buses and a train
My
to
pleasure.
get out
My
of
pleasure.
So really just, I think we'll have a good conversation this evening, and, a lot of IP protection is usually just focused only on patents, copyrights, and trademarks. But I think there's a lot more intellectual property beyond that, and many of those things that you do for businesses, and so I look forward to really digging into that. But before we do that, you have a very extensive background, and have an interesting journey. So if you take a few minutes to sort of chat a little bit about, introduce yourself, chat a little bit about your journey and key things that you learned along the way.
Sure. So I've spent the bulk of my career in the entertainment space. Primarily, I've licensed attorney in the state of New York, and I've spent most of my career in the entertainment space, with large chunks of it specializing in music. I started off my career actually as a litigator at a large law firm defending Fortune 500 companies in various types of business litigation. But I segued into entertainment, specifically music, and have spent a good chunk of my career in-house at major entertainment companies that that create content of all different types, from music content to television content to film content. I was at RCA Records as a part of BMG Entertainment for a number of years, and then on to Island Def Jam Records for a decade. And I also have my own law practice in New York City, focusing primarily on entertainment law and small businesses, and also some film and some literary work as well. I moved on from there to BMI, which is Broadcast Media Incorporated, also in the music space, but in a different niche, which is public performance royalties. And then before there, I was at actually Pandora Music, the streaming company, music streaming company, before going to BMI. And most recently, currently, I'm the vice president and head of business and legal affairs for music at Rock Nation. The company owned a joint venture between Sean Jay-Z Carter and Live Nation. So that's been my journey, my path. In my private practice a few years ago, a lot of my clients were, the majority were small business owners. Some of them were in the creative space. Some of them were more in the business space in other ways. But there definitely was, regardless of what industry they were in, there definitely was always something creative that they were creating. Whether or not they knew it, and whether or not they knew it was something that could or should be protected in some way, and whether or not they knew what they could or should be protecting was actually something that could become an asset later, is probably kind of the substance of what we're going to be talking about tonight.
Definitely. Look forward to talking a lot about that. So before we get started, actually, my brother's on, so he says, "What's up?" And glad to have him on the show tonight from Pittsburgh. And looking forward to really chatting with you about it. But before we get started, one thing I want to share is many of you may know we've been working on a Small Business Pro Network community for entrepreneurs and business owners. So we're starting to launch it now, and we got a quick video so you can see a little bit about what it is, and hopefully you join. So take a second, check it out, and I'll be back talking small business with Randy McMillan. What's the ultimate business ecosystem for helping entrepreneurs to accelerate and grow their businesses? Of course, it's the Small Business Pro Network.
I got to say, I'm glad I trusted you with your plan, because I like the plan, but we are, there's no guarantees, and it is a journey, but we're getting there, and we're making real solid progress.
Andrew helped me with the growth plan for my business, and also in the financial side. So we're able to get loans.
I thought it was great, good practical information that is good for both entrepreneurs or budding entrepreneurs. Andrew breaks it down in a very understandable way.
You need someone that's going to tell you how to get things done, how to move your business forward, how you can run your business like a pro.
I've known Andrew for 10 years, but when we started working together, I got to see the master's mind. And he's been helping me with my financials, making sure everything's together, what's working versus what's not working in my business, so that I'm working on my business and not in my business, period.
Join the Small Business Pro Network to learn from the experts, collaborate with like-minded entrepreneurs, and access valuable resources for growth. Hello, I'm Andrew Frazier. My mission is to help 1 million business owners by 2028 to sell more, make more, and get financing. I've worked with more than 1,000 business owners one-on-one, helping them to grow revenue, increase profit, and obtain financing. I created the Small Business Pro Network to help you achieve your goals faster and easier. Join before Labor Day to become a charter member for free. Visit www.sbpronetwork.com. I'm looking forward to seeing you there. Okay. Okay. Welcome back. Look forward to seeing you there as well. So, Randy, you've done a whole bunch of things on the entertainment side, but beyond just patents, trademarks, and copyrights, what other ways are there to protect intellectual property?
Well, I think that one of the things we should understand from a basic standpoint is that intellectual property really consists of largely those particular things that you've just listed. They largely consist of trademarks, trade dress, service marks, copyrights, and patents. But I think that the mystery sort of lies in what can be protected in those ways to create your intellectual property portfolio, if it were, of those types of assets. And I think, oftentimes small business owners don't see the product of their work as necessarily being protectable per se, or necessarily being an asset of the business. Um, I'll give you an example. You could have someone who's a consultant, and their consulting service is that they go into businesses and they help to train the employees about a particular subject matter. And so, in connection with doing so, that small business, that consultant, that individual who has a small business as a consultant may create materials. And those materials may consist of handouts, slides, articles, and other material that they create for the purposes of facilitating what they're being paid to do, right? Which is to teach this group of employees this particular subject matter. And so oftentimes what I found is that those particular folks who are small business owners, who are those consultants, may not necessarily understand that all those materials that they're creating are materials that are essentially intellectual property. Should you choose to protect them accordingly, they're intellectual property that can be otherwise monetized in some way or shape or form by turning them into books, turning them into courses, and also, and I think this is more importantly, um, it's often not thought of that these things are assets that one could actually sell with the business. A lot of consultants, they work in their business. They essentially have a job. Their business is their job. And they don't really think in terms of their consulting business as having assets per se. But you can sell a consulting business as much as you can sell any other business. But what gives it some real material heft and increases the value is if someone can purchase your business, such as a consultancy, and move into it, and then get all of the assets and tools along with it, physical and digital form, to allow them to be able to take on that business at the same quality level of materials that you've created over time. So those materials that you've created for purposes of training can be registered in certain ways and preserved and protected in certain ways with respect to copywriting your presentations, with respect to trademarking names and catchphrases that you may have come up with for certain areas of the subject matter that you present, such that these are all assets now, protectable assets that can be sold with a business. So you can sell not only a quote unquote book of business per se in terms of like clients, but you can also sell along with that assets of physical materials and digital materials that you've used in the business for the purposes of accomplishing the business goals.
Okay, great. So definitely looking at it from the long-term value of the business. Um, once you've protected your assets, there's different ways that you can monetize them as well. And what are some strategies around that you tend to work with people on?
I think in the past, one of the things that I've worked with people on is to really to dissect the substance of what they've created around their business or in their business that is distinctive. It may be a unique design or logo that they've created for their business. Let's say someone has an ice cream shop, or someone has a dry cleaner, and in connection with the outside of their business cards, their packaging, any and all materials that go in or out of the business that customers see, touch, or exposed to, those logos can be assets. They can be trademarks and registered as such and protectable under the law from others who may wish to try to copy them and to get the value that you've created from those for their own benefit. Those are assets, intellectual property that you can, they exist. It's whether or not you treat them with the respect of what they're deserved by getting them trademarked officially so that they're registered with the federal government. You have a trademark number. And again, you're creating an asset that can travel with the business. And it has value in it to the extent that you've built up the value of what that trademark means in the marketplace. You know, the golden arches of McDonald's have significant value in the marketplace because people see them and they are synonymous with a certain element of quality or familiarity that adds value to the brand. And so, you know, the same thing can be said for small businesses. There are a number of small businesses I know in my own community that have to do with certain types of services, like home services, whether it's plumbing or it's tiling, and people have built, or electrical work. People have built up local brands based upon the quality of work that they've done under those particular business titles. And as a result, they've come up with trademarks for those particular businesses that have value in the marketplace. If people see them, they're just like, oh, I know that plumber. I hear that they're supposed to be good. You know, even if it doesn't have the plumber's name, it could just be, you know, Swifty Plumbing. You know, there's some value in that. And, you know, people come up with these things in the context of sometimes the early stages of their business, where they may come up with mottos or, of course, trademarks. They may come up with certain catchphrases. They may even come up with their own sort of terms of art for different packages of services that they offer that are unique and unique to their business. And those things are the types of intellectual property that you can protect, but you have to sort of look at your business and dissect it and pull out the things that, you know, hey, I came up with that. Hey, nobody has that, or nobody does this way, or nobody really, when they explain, you know, this, presents it visually in this way on a slide. It took me months to come up with a way to make this really, really simple, and everybody seems to get it. That's a unique, distinctive proposition of a way to communicate an idea that is uniquely created by you and could potentially be copyrighted. All in all, it's the intellectual property that you have invested and that you've manifested in the context of working on and in your business.
Okay, excellent. So, you know, one thing I find with many businesses, especially early on, is the name and logo may change. You know, for example, you know, my original business name was A&J Management, but after a certain number of people kept asking me, "Do you do property management?" I was like, maybe that's not a good name. So, you know, I changed it to Small Business Like a Pro, so people understand better what I'm doing. But you know, definitely early on, you know, there's flexibility, things change, and also your brand is more you as a person. Um, so if you're starting out, what would you recommend people do as far as their logo and any other intellectual property that they're starting with?
Yeah, I think that, and that's a great point because you're right. These things can change over time. And I think that one of the most important things to do in the beginning, when you have something that you've created, say it's a logo or trademark, or some type of marker way that you're identifying your business graphically, visually, I think is to, as much as you can, use it wherever you can. And I'm thinking about this in the context of putting it in the marketplace in a way where it's clear that you've committed to it to a degree, and that you are using it in commerce and out in the public and trying to do business with that. And if you put it on any merchandise that you leave with customers, or any materials that you may distribute amongst potential customers, or you use it as the footer in your emails. Because what you're doing is, you are, in effect, by using it, you're protecting it. Because what you're doing is, you are, over time, you're associating the use of that solely with you and your business. This is the way that you sort of build evidence of your use and your claim to a particular type of logo or service mark, that we would refer to as intellectual property. So, if in the beginning, I would not say that you run out and invest in, particularly maybe trademarking every logo that you come up with. But certainly, if there's one where you're going to be investing significant sums of money into, and you're renting out, thousands of square feet of a commercial space, you are bringing a new business type to a community area, had some designer design a particular logo for you and you're going to create signage that's going to cost you, a couple $1,000s or more to put on the outside of this building that's going to reflect this particular trademark. I would say that you might want to bet on winning. And with that kind of capital investment in the trademark, you're not just putting it on the footer in your email, you're actually investing in it in a real material way. I would say that the stakes are higher there, and you may want to consider, even from that sort of fledgling level, thinking about applying for trademark protection for that particular logo that you've come up with. Because chances are, if you're operating in a physical environment like that, you're going to be investing in a lot more with respect to the use of that logo than just the signage outside. It's probably going to be on your napkins. It's probably going to be on your bags if your goods are sold and people walk out with a bag with that material on it. It's probably going to be on merchandise that you may sell in the store or in the business. It's probably going to be on materials that you hand out when you're doing on-site marketing someplace else for your business. So those types of real capital investments in the use of a logo tend to make me lean towards advising my clients in the past that they should definitely, seek to apply for an application or apply to register that trademark as their own and owned by their business, as opposed to maybe waiting a couple years or so, because foregoing that and not aggressively using the trademark the way I was describing, you could be leaving open the opportunity for someone else to come along, and maybe copy some elements of that logo that seem pretty cool, but maybe they feel like if they applied it to their business, that they might get more traction and growth from their business from some of the elements, the creative and visual impact that yours has. So when it comes to things such as that are visual representations of your business, use them, and use them as much as you can out in the marketplace so that people see them as much as possible and identify and associate them with you and or your business.
Okay. No, great points. So now if you're going to use them, so if you're just starting out, you want to use it, how long should I use it for before I think about actually officially trying to get a trademark?
That's a great question, because it's a segue to the fact that the U.S. Patent and Trademark Office, which is where we register and apply for trademarks, requires that you provide some proof of use of the mark ahead of time in the marketplace. So the advice that I was just giving about using it and using it as much as possible in commerce in one way, shape, or form, and doing so over, your question was specific to how much time. I would say that certainly if you've got active use of a trademark for, 6 months or something like a year, I think you've established a good foothold and probably could produce a lot of pieces of evidence, because that's what you have to submit with your application. For example, if your business is co-sponsoring an event that someone is having, if there are any marketing elements around that, like sometimes you go to an event and they have like a brochure, here are all the people who are the sponsors. You want to keep those. Those are evidence of you doing business in the marketplace. If there are flyers that are being distributed in the marketplace, if someone produced, say, T-shirts for a walkathon for, to fight cancer or something, and you were a sponsor and your business's trademark is on those T-shirts, keep that. Those are all evidentiary pieces that help to substantiate your application for your mark, which basically says, hey, this is mine. I created this. I've been using it for a while in connection with my business, not some other business. I didn't let my friend use it for their business, but solely for this business. And I want to register this now because clearly, as you can see from the evidence that I've produced, I'm serious about this mark, about this logo, and about continuing to use it in my business and to make sure that I have it protected, and protected by the federal government in particular.
Okay. All right. Cool. So now, one question is, I probably know the answer to, but I'm going to ask you anyways. Should you get an attorney to file your trademark, or is that something you can do yourself based on directions on the on their website? And, also when you're thinking about trademark, should we or should we not use TM before we actually get our trademark registered?
Okay, so my suggestion on the first, I think that 20 years ago, I would say that one should definitely, I think, get a lawyer to do it for them 100% of the time. I would say since then, in the last 10 years in particular, I think the U.S. Patent and Trademark Office, frankly, has done an exceptional job at upgrading their digital and website portals to make the application for protecting your intellectual property, whether it's trademarks or copyrights or what have you, much more accessible, much clearer to follow in terms of process. And certainly, I think much more communicative in terms of the status of your application and what, if anything, is needed to be submitted in support of your application. They've done a great job of upgrading those systems. And frankly, someone who may be, not necessarily a lawyer, but otherwise detail oriented and technically inclined in some way, familiar with use of online portals and completing fields and drop downs and other things that maybe some people take for granted when they're interacting with their computers and online. If you're pretty comfortable with those things, I would say you might want to give it a shot to try it initially. Um, at the same time, applying for a trademark is not the end of the process. And things come up during the process of trademark application in particular, where they may reach out to you because there are other people who, through their search, they find are in the marketplace who have something similar to your mark. And those are instances where it would be in your best interest to have an attorney who's familiar with intellectual property and familiar with the patent and trademark application process to help you to craft arguments that you may need to craft to support your mark being something that is protectable, even if they find that they think that there's another mark or material out there that may blur the lines with what you've come up with and somehow make them think that maybe your mark shouldn't be protected because this other mark is already out there. A lawyer who is very well versed in this subject matter will do some research and some interview work with you and some marketplace research to create a basically cogent arguments, compelling arguments to present to the U.S. Patent and Trademark Office to support your application for your logo or other marks to be registered in support of your business. That's not something I would try to do on my own if I was not an attorney. And even myself being an attorney, I think that there's always value in expertise in a particular area and subject matter. So if I got tied up in a particular trademark issue with the U.S. Patent and Trademark Office, I would certainly consult people I know who are lawyers who do trademarks every day, and that's all that they do. Because oftentimes when it comes to this and other areas of the law, it's not being able to interpret and understand what you see and what's in front of you in the text and in the documents or in the laws or the statutes. It's what's not there that needs to be there in your best interest. And so people who know what's missing are the people who have the greatest expertise in that area and familiarity with that subject matter. And you always want those people on your side when the going gets tough and you find that you need to have some staunch advocacy for your position.
Hey, you were the first lawyer I ever heard of that said you didn't necessarily have to have a lawyer.
I mean, I've looked at this over time. I definitely think, is it easier? Yes, it's absolutely easier if you get a lawyer who has expertise in this area. And oftentimes these processes, for the most part, go pretty smoothly. So there are not a lot of surprise expenses. So most lawyers who specialize in the area can give you a fairly on point estimate of price. And it's not crazy expensive when you think of it relative to the value that it has in your business. Because how we started off our conversation, we talked about how these are assets, right? It's not just, oh, why do I have to get a trademark to just put it on the front of my business? No, it's an asset. You're investing in it to make sure that it is firmly yours, because down the road, you may want to franchise that asset. You may want to have 10 other people who have their own, facilities that are branded with your business. Well, you're not going to be able to really do that effectively if you haven't trademarked that logo and the other associated signage and messaging and mottos that work around that as well. So if you're thinking long term, if you're thinking in that you're going to win and that this is not just going to be, a flash in the pan effort, then you need to be thinking about, let me protect this mark, let me protect this logo. And this is going to be worth something in the future because I know what I'm investing in this business. And just to backtrack one point, Andy, on what you said about how sometimes those things change over time. You know, there's nothing wrong with having a portfolio of trademarks where you have more than one. You
Mm.
know, businesses don't always stay in the same line of services. Sometimes you branch off and you'll have, an arm of the business that's now just focusing on this piece of the business, and another line that is still following the initial business model, and if you have multiple trademarks that you can use, then you can apply them as needed. There are many brands out in the marketplace that we're all very familiar with that are owned by companies like General Mills or Anheuser-Busch or whatever, where they have brands for beverages or brands for products that have been off the shelves for 25, 30 years. And the same goes true in the entertainment space. There are record labels that nobody's heard from for like 25 years. And then people will decide, those businesses who actually own those trademarks and have them registered will decide, you know what? We need like a new brand for this new genre of something that has come up. And then people talk about it and they say, yeah, what are we going to come up with? And they toss around all these ideas to try to come up with some fresh and new, unique name or logo. And then they say, you know what, though? Everybody knows X. Everybody's familiar with that brand, that old brand. Why don't we take it and freshen it up for this new genre, for this new marketplace, for this new product, for this new service? It already has some value and familiarity in the marketplace. We don't have to create that. We can just transform people's perceptions of it and how their familiarity with it. And people do that all the time. And you need to think that way as well about things that you create. They have that potential long-term value as well. And so that's why I think, to address your comment, Andrew, about, logos sometimes changing over time and whether or not you should or shouldn't try to protect them officially. They could have long-term value that you haven't yet perceived of.
Okay. No, that's makes sense. So, another example of that is Acura's coming out with the Acura Legend again.
Oh, wow. That's
So,
a great example. That's
so
a
I'm
great
like,
example.
hey, that was a cool car. I can't wait.
Yeah. Absolutely.
So, definitely
Ab-
has a lot of value.
Absolutely.
So, so you know, we talk about protecting what we have, but before we have what we have, what should we do to make sure it's protectable? Like, are there searches we should be doing before we even choose a name?
Right.
One thing that I've heard is and recommend is, if you can't get the domain name for your name, then that probably shouldn't be your name. So what type of preparation should go into things even before you settle on a name, settle on a logo?
Yeah, no, definitely. One, two, three things I would do. One, I would search. Many states have databases that you can search for the names of businesses. I would search that database to make sure that there aren't other businesses already in the marketplace that are using that name, and or that business title or name that you're probably maybe thinking about converting into some type of a logo at some point in the future. I would also check the U.S. Patent and Trademark Office website, which is uspto.org. You can do a search in there as well, to be able to see if there are any potential conflicts out there with what you're planning and what your ideas are for your branding of your business. And then thirdly, I agree with you 110%. You want to go on a website that where you can register you can secure a website domain name, and you want to search for any potential domain names that are available that might use or incorporate the name of your business in some way, shape, or form. And oftentimes, just that search alone will then kick off or jumpstart a more general Google search, because you may find that there are some names that come up that maybe they incorporate some of what is the entirety of your business name. So your business name, might be, amazing people, and the domain name is, blue amazing people. But that'll kick off some interest there for you to do a further search, to go to that blueamazingpeople.com and see what are they doing in terms of services. Is there any potential likelihood of confusion in the marketplace between what they do and what I do? And you may ask, well, why is that important? Because that is one of the main barometers that the US Patent and Trademark Office uses in determining whether or not they're going to approve your application to protect your trademark. They don't want to approve trademark applications that are going to in any way confuse the public when they're out in the marketplace as to what business they're actually doing business with. So if you have a business that's called, Blue Opal, so to speak, Blue Opal, and your business is that you do general contracting, there could be another Blue Opal out there. But if that Blue Opal is a restaurant that sells Caribbean food, the likelihood of there being confusion in the marketplace between your Blue Opal general contracting business and that Blue Opal restaurant is highly unlikely. And that's what you'll say to the US Patent and Trademark Office if they raise any questions about your application to protect your general contracting business logo, is that the likelihood of confusion in the marketplace with your typical consumer, that we as a general contracting firm and them as a Caribbean restaurant are going to confuse consumers, highly unlikely. Grant my application. You want to be in that position. I think also, if I just may jump back one point, in terms of another thing that you can do to protect your intellectual property, in particular things like logos, Andrew, is you can, you really are not allowed to put the small little R with the circle around it on your marks until you actually have received confirmation from the US Patent and Trademark Office that your trademark has been registered. That is the indication that something is registered, and that if someone has any questions and wants to inquire further, they can go to the US Patent and Trademark Office, and they should be able to put in the name of that business or whatnot and pull that up. So you don't want to prematurely sort of put something like that and associate it with your mark if you haven't registered it, because it's really kind of false advertising, frankly, in terms of how that asset is credentialed or lack thereof, frankly. So,
Okay, great. Just a comment, you know, definitely about event sponsored, value to sponsors. And, of course, she does event sponsorship and she's really great at getting sponsorships. But that's another reason to think about why you may want to sponsor activities and events. So
it is.
Cool. So, one other thing we sort of danced around, but probably like a Google search or multiple Google searches on your name and other stuff. And because I ended up at Small Business Like a Pro because there was Small Business Pro, but there was zero Small Business Like a Pro. There was zero Small Business Pro University. So, and I could get the domain. So definitely, if you can differentiate yourself like that, because also I come up on the first page on Google searches on any of those things. So the trademark office, you know, that's proof because they're definitely going to check that out. So you
Absolutely. Absolutely. I agree with you 110%. They're going to check that out for sure. And without a doubt, as you just mentioned, search engine optimization of your business name is key in today's society to being able to get as broad a market as possible to have access to your business and your services, because it is the first place that people go to look for you, even if they don't know you exist. And then once they do find out you exist, to look further into you and to find out what people think of your businesses. So I think that that's definitely a key. It goes without saying. First step to take when you're trying to decide, what am I going to call my business? Who else is out there in the marketplace that's close or competitive, and how is this going to make my business name either more challenging or less challenging to protect and to be able to get traction for in the marketplace.
Okay, cool. So we've covered trademarks pretty well. Want to shift to copyrights. Before we do that, I've got a quick commercial break. My next Small Business Power Breakfast is going to be October 27th. So, we've been doing it for over 10 years now. Had over 1,000 attendees, help people get millions of dollars in financing as well as economic opportunities directly as a result. So October 27th, there'll be more details, but make sure to register early because space is limited. What I want to do is, just so for those of you who aren't familiar with the Power Breakfast, I'm just going to show you a quick video and then we'll be back talking small business with Randy McMillan. If you are looking to increase revenues, improve profitability, and or obtain financing for your business, you need to check out the Power Breakfast and Small Business Pro conferences. My name is Andrew Frazier. One of the things we're here to do is supercharge your day.
Today's Power Breakfast has really been a phenomenal experience. I think it's exactly what business owners need, some true guidance of people who are genuine and really are leading them in the true direction of business growth and expansion.
The Power Breakfast is so important for the entrepreneurial community because it gives the various business people who come together an opportunity to interact and also do some business.
These events, hosted by Andrew Frazier, President and COO of Small Business Like a Pro, will supercharge your day. All right, welcome back to Leadership Live at 8:05. So let's talk a little bit about copyrights because, definitely, you hear about them, you hear like the old tales, just put something in an envelope and mail it to yourself and keep the stamp, or just, put copyright on it, or, you can go to the website and actually do it with the government. Talk a little bit about those options, what they mean, and what, whether they're even viable.
Sure. So just generally, what does it mean, right? It's copyright law and the protection of things with copyright law is really for the purposes of protecting creative output. And that can take many forms. In my day-to-day business, much of my career, that creative output has been songs, or recordings of performances, or movies or music videos. But for many small businesses that may not be in that space, it can apply to content such as books, manuals, computer software, architecture and specific designs. All of those different things are things that are creative output and are copyrightable to the extent that they are ideas that have been reduced to some type of tangible form. So I think it's one of the things to keep in mind is that one of the big differences there is we're not talking about particular, as we spoke about previously, um, logos or trademarks or things that sort of brand a business. We're talking largely here about the output of a business or people who work for the business. You may have a team of folks who are creating software for you, and that software is a unique way of accomplishing a particular goal in terms of output through a computer. And you may want to copyright that process or that map of how to execute a certain goal on the computer that's reflected in this software. In terms of authorship, we spoke earlier about the small business that creates, a book or other materials from what they use every day for purposes of accomplishing their goals in their business. They may be in a service business, and part of their business is to render a certain service. And as tools in doing so, they create books, they create pamphlets, they create slideshows, and all of those things are copyrightable materials, assets, intellectual property assets that you can amass around your business. And we talked a little bit about those assets being things that are transferable. Someone can purchase your business, and with the purchase of the business, you say, hey, price A is this. If you want to buy the business without these intellectual property assets, and price B, if you want to buy the business including all of these intellectual property assets. So the idea of what that can be anywhere from some of those tools that I just mentioned. And it doesn't always have to be, and this is an interesting thing to think about, it doesn't always have to be something that is particularly appertaining to the execution of the business itself. You could have a plumbing business, and the owner of the business creates, or with their team of plumbers, creates a guide for the homeowner for how to manage and oversee their steam hot water heat system, such that if there's a problem with it that doesn't require a professional, and it's something that's more like maintenance, like making sure it's filled with water and draining it every so often if the little dial on it gets dirty or clogged. This is a book that business could produce and could actually sell, branded with their business, which is in that industry. Now, you don't need that book they don't need that book in order to render their services in any way, but it's an extra value product that business can sell in addition to the services that they render in the industry. Not only is it an asset that is sold that people can purchase, but it also it reinforces expertise in the subject matter. It also builds goodwill in the marketplace because consumers perceive it as, wow, this business cares so much that they made a book to show me how to do some of the work myself so that I don't have to call them. Kind of thing that resonates with consumers in the marketplace and sort of reinforces the perception of that business as a market leader.
Okay. So one of the big challenges is, my guests are such experts and knowledgeable that an hour just isn't enough. So, once again, we're just getting started, and it's pretty much an hour. And usually we do as a guest to give 3 key takeaways of things people should be thinking about tomorrow with their business. But also, we have several questions, so we got to do a speed round of questions. So I'm going to give you all 4 questions, and then you can do your fastest answers, and then we'll close it out with the 3 things that people should focus on. So my question is, if you have a book that's copyrighted and your materials in the book, should you also copyright your methodology outside of the book individually as well? So it's sort of like, should you have a copyright inside of a copyright, sort of like a dream within a dream?
Right. And you want me to answer these questions one as you answer,
Yeah,
right?
rapid fire.
Yeah, sure. Okay. So yeah. So the copyright of the book is protecting the expression of the ideas of the book. So the book is this thing. It's got a lot more going on in it. It sounds like than just the methodology. And so the methodology might be just one. It could be a table that's in the book, right? It's just like this methodology or graphic that's in the book. And so I would say that as a business owner, if you've self-assessed some of the value that we talked about in terms of the uniqueness of that particular methodology and your ability to be able to represent that methodology in a tangible form, you can, because you've got it in the book in some way, shape, or form. I believe that methodology has a value all unto itself and is an asset unto itself, should it be so protected. Because if you think about it, you could certainly take that methodology and monetize that methodology way beyond the scope of just a book. And you could have a team of people who learn that methodology. You could train those people on that methodology globally. You could have books that are derived just from that methodology. So yes, the same way, and I'll use this analogy, the same way as, if I was putting together a compilation of songs by Andy Frazier, I would want to copyright each of those individual songs, not just the whole album of Andy Frazier works, but each of those individual songs, because I could think of a lot of different ways that I could exploit and generate revenue associated with each of those Andy Frazier songs beyond just that compilation album of them.
Okay, great. Sounds good. So next question real quick. Is there a maximum number of copyrights that can be obtained in a year?
No, I think that, well, practically speaking, the answer is probably yes, because the U.S. Patent and Trademark Office, can only put through as many as they can put through. In terms, just they can delay, if their volume is too high. That's that's not unusual, particularly during COVID. They were short-staffed in a lot of different ways. But in terms of you applying for them, no. In fact, actually, one of the things that they've had a move towards is allowing people to actually register groups of works together a little bit more efficiently. There's been a move towards that I've seen the office do, where you can, like, if all of these items have to do with the same thing or something similar, or they're somewhat duplicative to some degree, you can register them as a package kind of, or a group. And so that's, one of the things that I've seen, but there's no sort of documented like limit, but there's a practical limit, of course.
Okay, great. So this next one's a yes or no question. Your professor, consultant, our curriculum syllabi copyrightable?
Curricula and syllabi are copyrightable to the extent that it would have to be very robust, and it would have to be curricula and syllabi that really effectively kind of represent a particular idea. So just having, for example, a bulleted outline of, say, for example, different books you're going to read or different concepts that you're going to address in a course, that's not enough. There's got to be some element of creativity that we're trying to create, that we're trying to protect. So I would say that curricula and syllabi, it might be a little bit more challenging, but I think the challenge would come down to the uniquely creative expression of that curricula and syllabi. I'm certain that I think that you could probably have a unique presentation of curricula and syllabi that might be copyrightable to the extent that nobody else does it that way, and presents it that way. So think about the ideas, think about creative expressions of an idea, unique creative expressions of an idea as being something that may be potentially copyrightable.
Okay, cool. And then can one copyright be granted over another if one side presents a more compelling argument? So if they're, two copyrights in the same business industry.
Yes. We've seen this happen in the area, particularly of music, where people have, you've probably heard about music sampling in music, where people take excerpts from one record and put it into another, or that's a pretty clear path, or you have a record or a song that conjures up another record that may be from 20 or 30 years ago. And you'll have lawsuits that come as a result of that, where the party who has the new recording is arguing that this is original. I didn't derive any of this from anyone. And the owner of the older recording from 25, 30 years ago is presenting a more compelling argument that, well, while you may not have intended to do so, elements A, B, and C of your new work are all present in my work in exactly the same pattern, emphasis, and melody as your new work. And so it becomes a back and forth in terms of the more compelling argument that can be there. Now I think the question talks about, can a copyright be granted over another? I was actually talking about where, arguably you have parties who are arguing over who should have the resulting copyright there, or there's copyright infringement per se that's happening there. But in the beginning, when you're registering for copyright, the level of scrutiny by the USPTO of your entitlement to that copyright is not at the same level as it is in trademark. So I think what you should be aware of is that there may or may not be a sort of counter argument in the context of applying for a copyright registration, because that's a little bit more automatic. The trademark process is a little bit more involved, a little bit more judiciousness going on with the USPTO in that process.
Okay, excellent. So actually, we've covered a whole bunch of stuff. We didn't get to patents, but I think most small businesses don't really dabble in that area, and that could be a whole show in itself. So we'll let it go from there. But are there anything you want people to think about as we close out?
Yeah, I think that every small business has things in it that have been created that can be assets that go beyond just the physical tools of the trade. A mechanic has intellectual property that they haven't even necessarily thought about. It could be a particular unique way that they approach a problem, or a particular unique way of solving a particular problem, or a particular unique way of teaching something to consumers. And I think that small businesses need to, beyond just working in the business, small business owners, beyond just working in the business, need to spend some time dissecting the unique and distinctive things that they have come up with in their business, whether it's the logo, or whether it's the materials that they've created in order to achieve the goals of the business. It could even be a physical tool, that someone has created in order to be able to accomplish some particular goal, and that may benefit for something like a patent. For example, if a mechanic develops a particular tool that he hand fashions, that's something that could be protectable. So take stock of all your creativity that is coming out of your business, whether you know it or not, and consider whether or not it's something that could be an asset that no one else has done or created for you.
Excellent. Great way to end the show. Thank you so much for coming on.
My pleasure. Fun.
Yeah, appreciate you sharing your expertise. We'll have to get you on here again in the future, so that we can continue the conversation. Hang out for a few minutes. I'm just going to close things out, and we'll go from there. So definitely appreciate Randy coming in and sharing his expertise. This is very valuable information for entrepreneurs and business owners, because many times we're thinking about so many things that we forget this, or we don't really know what we should do, so we're more worried about it than we should be. So I think this sort of provides knowledge and expertise and a better understanding for how it can apply to you. Looking forward each week. We have new guests, and next week's going to be pretty exciting as well. But we're going to get out of here in one sec. So, one thing that's key as a business owner, at the end of the day, the more that you know, the faster and more successfully your business will grow.
Thank you for listening to Leadership Live at 8:05, Talking Small Business. Subscribe to our YouTube channel and to the podcast on your favorite podcast platform. Leadership Live is one of the many valuable resources provided through the Small Business Pro University, empowering business owners to learn, profit, and grow. Find out more at sbpro.u.com.